SJC-12789, Commonwealth v. Darrell L. Thomas.
Good afternoon, Ms. Blanchette.
Good afternoon, Chief Justice. May it please the court, I'm Madeline Blanchette, and I represent the appellant defendant Darrell Thomas. To answer this court's question, no, the legislature did not intend 18B to be applied to assault and battery with a deadly weapon. What I think is very important to start with when looking at 18B is what I call the gestalt of the statute. And this court talked about that in a very clear way in Commonwealth v. Hines when it explained that the legislature undoubtedly—
One thing, you're talking very loudly.
Oh, I'm
So-
sorry,
yeah,
Justice.
thanks.
Yep. When the legislature undoubtedly recognized that drug offenses frequently involve drug dealers being armed and that, in many cases, shootings and killings occur when a drug dealer is confronted with police. So this is what the legislature intended with 18B. It is a specialized statute which attempts to identify and capture a very specific type of misconduct where someone in the process of a felony is possessing or using
But what
a
do we
gun.
make of their deletion of the express prohibition? Because that's, you've been sitting here patiently all day. We have a lot of sort of screwy statutes we're dealing with. They removed the thing. Shouldn't we give that some significance?
What I think is more significant, Your Honor, is that they declined. This court agreed that when the statute was rewritten in 1998, it was following the suit of its federal equivalent, and 18 U.S.C. 924. And what I think is really significant is that they did not follow suit of the federal statute, which specifically said that this statute would include a crime of violence or drug trafficking that provides for an enhanced punishment if committed by the use of a deadly or dangerous weapon or device. So what I argued in my reply brief that is, if we're going to be looking at what's—
Can you flesh that out? I just want to make sure I understand your argument on that better. Go ahead.
Okay, so you're absolutely correct that when the legislature revised 18B, they did drop that sentence that explicitly excluded crimes that were wholly predicated on the use of a handgun. But what I think is more germane and speaks louder, and certainly under the teachings of this court in Richardson, is that they declined to follow the federal rewrite of the law and explicitly include those crimes. So, and in my principal brief, I did include some information that I could glean about legislative intent, and it appears that there were two main things that the legislature was going after. Number one, they were trying to add gradations of punishment for people that had used high-capacity weapons and machine guns, which was a new phenomenon since the last rewriting of the statute. There's that, and then they tried to capture more cases, again, in this gestalt of like the drug trafficking plus gun. So you didn't have to just use the gun, you could just possess the gun. And again, that's where this court in Hines came up with this helpful test about the nexus That's what the appeals court has followed in the case Golding, where you're looking at one type of felony misconduct, and then it's enhanced if you're using a handgun, but not something that is essentially totally predicated on using a handgun, because that then would get into the requirement that there's clear and explicit language that that's what it's after.
I'm just, again, I'm back to, so when they delete the language, in your view, that has no significance. We're exactly where we were before they deleted the language.
I believe that we're back where we were, Your Honor, and in 22...
Why do it then? If it's exactly as is and it was clearer before that you couldn't do that, why do it?
Well, as I argued, this wasn't a rewrite of a statute that went line by line. They pretty much wholesale took out all the language from 18B, and then they put in language to reflect the changes to the federal equivalent. So I agree that little provision ended up on the cutting room floor, but I don't think that is any, I don't think that's indicative of intent, because I think the statute, the history of the statute, the fact that in 22 years now, there's no appellate case where 18B has been applied to a predicate offense like assault and battery with a deadly weapon. The whole purpose of the statute would be totally eclipsed. So therefore, I think that it's still intrinsically and internally consonant with its pre-1998 form. I would also say that in the case of my client, even if this court were to find that it could be applied to assault and battery with a deadly weapon, that it could not be applied to my client because he had 2 charges of assault and battery with a deadly weapon, and they were already both enhanced with the habitual offender statute. So again, there is nothing in the rewrite of 18B that allows it under Richardson, no clear language that this statute can be used to get up and over the prohibition against double jeopardy. And I would argue that the Commonwealth...
Again, I must be slow because it's a long day. So tell me exactly how that works from double jeopardy. So they've enhanced these 2 A and Bs with a deadly weapon, and they can't add this other enhancement.
Right, they can't stack enhancements under Richardson unless the statute explicitly says that you can pyramid enhancements. And because of that, then the Commonwealth has attempted to I don't know what the word is, but basically construct a third uncharged crime for my client, and suggest that somehow the jury knew to not apply 18B to the other assault and batteries with deadly weapons, and that they should look for a third one in the evidence.
Can I back you up again before you go into that?
Sure.
So why isn't the statute an express permission for a pyramiding? Why do we read it as not doing that?
Because there's no clear and distinct language allowing for that. And in the federal statute there is. It says not only can this be predicated on a charge that wholly involves a weapon, it would still be okay even if that charge were enhanced already.
And you say the habitual is an enhancement, even though I think the habitual statute simply says you're obligated to impose the maximum under law.
I would say that habitual is an enhancement statute, yes. Yeah. And I would say that, that under, I would certainly say that. And I also would say that even the fact that we're talking about 18B, and I'm posing one interpretation, the Commonwealth is interpreting it another way, that under the rule of lenity, then my client would prevail.
Okay, thank you.
Okay, thank you so much.
Mr. Bowden.
Good afternoon, Your Honors. Nathaniel Bodwin for the Commonwealth. I would answer the court's question on FAR. Yes, ABDW can serve as a predicate felony under 18B. And if you look at the legislative changes that were made in 1998, all those changes actually expanded the reach of the statute. Excuse me. They expanded the reach in terms of, prior to that, the statute required that a defendant utilize a firearm during the commission of the felony. They changed it to simply possessing a firearm. They obviously took out this provision regarding dangerous weapons. And I agree with the defendant's characterization that the legislative intent was to deal with, the issues going on with high-powered weapons. So the legislature also added new and additional penalties for firearms which were semi-automatic, high-powered weapons. There's also been some discussion in the briefs that we should compare this to the federal statute. But if you look at the language of the federal statute, it is actually much more restrictive than our statute. The federal statute states that the predicate felonies can only be crimes of violence or drug trafficking. Our statute simply says any felony. And the Hines decision sort of reiterates that and says, yes, the legislature could have restricted it. They chose not to, and it applies to any felony. And there are some decisions, although they are unpublished, where the predicate felonies were not crimes of violence or drug trafficking. In the Morris case, it appeared to be the possession of counterfeit notes. In the, and I'm probably pronouncing this wrong, Larace, L-A-R-A-C-E, the predicate felony was receiving a stolen motor vehicle. So I think that goes to show that, again, the legislative intent would be that this would apply to any felony, including those involving dangerous weapons.
So let me ask you that. Would it, under your interpretation, would it apply to the felony of the illegal carrying of a firearm? It fits the language.
I believe that it would, Your Honor.
So the legislature intended then to have a 5-year minimum sentence for the carrying of a firearm by enacting 18B.
I believe we have to read the statute as it's plainly written. So yes, Your Honor.
But that's not what but that's not what it imposed with regard to the illegal carrying of a firearm statute. I mean, isn't it? I mean, this is weird here. So it's now, according to you, there's now a 5-year minimum for A and B DW when the DW is a firearm.
That is correct. That is what I'm arguing.
Has any, I mean, do we have any, if we look to see, has any other DA attempted to do this, to basically use this for an ABDW? The first time we've dealt with it.
And yes, and in my letter, I did say that the only case I could find where ABDW was the predicate felony, it was an unpublished decision, Commonwealth versus Kelly. So that is the only case that I could find where this case was, but let me also say that wasn't 18B, it was a similar statute, possession of a firearm with a defaced serial number during the commission of a felony. So I would argue it's very similar statutes.
If you're right, then any time there's the possession of a firearm during the commission of a crime, including, as you state, the crime of illegal carrying of a firearm, the legislature intended there to be a 5-year minimum sentence.
Without any further clarification from the legislature beyond that, I would say yes. And I would also...
Let's look to, I mean, I looked at the entire statute. It is, I went back to the actual language of the 1998 statute. I mean, there are enhancements, armed robbery, whoever commits any offense described herein while armed with a firearm, that for armed robbery shall be punished by imprisonment of state prison for not less than 5 years. So are you saying then that when the legislature did this, you could say, okay, you're guilty of armed robbery with use of a firearm, you must get not less than 5 years, and then we could charge you under 18B and give you another 5 years? We're obligated to do that.
That is correct.
That's what, then why would they say 5 years on the top of the page? It's all on the same page. 5 years for armed robbery with a firearm, and then at the bottom of the page say, well, it's actually really 10 years because you have a firearm. Same thing with regard to assault in a dwelling, same thing with regard to assault with intent to rob, same thing with regard to entry into a dwelling, carjacking, rape, rape of a child. All of those have enhanced sentences when the use of a firearm is there, and you're saying any of those can then be enhanced again under 18B. That's what the legislature meant to do.
What I should make clear, Your Honor, is that my position is that 18B is actually not a sentencing enhancement. I believe it to be an independent crime.
Right, I understand that.
Okay.
So basically,
So-
you would have to get
So there are
the
there are other
mandatory, you have to get the
enhancements that
minimum
could
here,
apply.
and then you would get a separate crime charging, basically, you committed this crime with a firearm, essentially the same thing, and now we have to sentence you to another 5 years.
I think both parties here agree the legislative intent was to deal with the issues of firearms in our society. They wanted to further punish individuals that carry firearms while committing felonies, any felony, and
Including the felony of the illegal carrying of a firearm.
How about double
Why
jeopardy?
isn't that
Why-
multiple punishments?
Right.
What is it? I haven't thought about this for Kaufman versus Hunter, maybe? You can't have multiple punishments for the same crime?
It's the same offense conduct.
I have to admit, I mean, this issue of illegal possession, I did not, look into this issue before it was addressed here today. So if you'd like me to follow up on this
Well,
issue with illegal
you're
possession,
welcome to.
I'd be glad to.
Some more questions.
Okay.
A and B DW, that statute was amended in 2002, to add the provisions with regard to serious bodily injury. But no minimum. It just simply said now the maximum is higher. It's a maximum of, I think, 15 years. So 4 years after this statute is done, they address the issue of ABDW, which now includes serious bodily injury, which is permanent disfigurement, loss or impairment of bodily function, limb or organ, or substantial risk of death. They say no minimum 5 years, but it's a maximum of 15 years. But you're saying that what they effectively did was there's now a minimum of 5 years if that serious bodily injury was caused by a firearm.
And I would have the same response, Your Honor. I believe the legislative intent was to further increase the penalties when defendants possess firearms, when they commit any felony.
But you just said it was a separate crime. Now I'm getting confused, because if it's a separate crime, you've got double jeopardy problems, because it's the same, the firearm's doing double duty, isn't it? I thought your argument was it was a sentencing enhancement.
To be honest, it wasn't addressed in the letter. It was dealing with that issue with the amicus brief, because that issue was raised more whether this court is going to say this statute is a independent felony or a sentencing enhancement.
Well, don't you have if it's a separate crime, aren't you running smack into double jeopardy? Because the elements are, how is the second crime not have the same elements? I guess maybe it does. I don't know. I'm just trying to figure out how, under Vic in those cases, how are we getting different elements here?
It would depend on what the predicate felony was. In
Well,
terms
the
of
I'm doing our case. Assault and battery with a deadly weapon. Okay, it could have been a knife, I guess. But we have a gun in both places. What is the crime, if it's a separate crime as opposed to a sentencing enhancement? What is the second crime?
Well, would be a violation of 18B. The legislature didn't explicitly say that you cannot use, this has to be independent. The legislator didn't say that that the Commonwealth was barred from bringing this statute, even though the predicate or root felony involved a dangerous weapon.
Well, it has to be it's more than an enhancement because it says, in addition to the penalty for such offense, be punished by. So there must be a penalty for the other offense.
And the way I read that, Your Honor, is though I doubt this statute would ever be brought by itself, and I think that part about when you take into account the previous sentence, that's considering whether there are other charges.
Right, so
As part of the
there must be another indictment for a felony, which there's a conviction and a sentence, and then this 5 years is to be a separate and distinct sentence, which can be concurrent, or it can be suspended, but it has to be a separate and distinct sentence for a separate and distinct crime.
I don't think it makes clear there has to be another sentence. I think you can charge this independently, but I understand where you're going with that there is likely to be a sentence for the root felony.
But then you have the language, in addition to the penalty for such offense. So doesn't that infer that there has to be a
If
conviction
there
of
is
another
another
offense?
charged offense.
Okay, but here, of course, there was, at least unless you go to the appeals court view, that there was this, which you're not pressing, I gather, are you?
I'm not pressing anything further, no.
Okay, you're not pressing the appeals court argument that we can rely upon the uncharged ABDW as the basis for it.
Correct, and I think they analogized it to felony murder,
But
yes.
I'm confused, though, because your brief is arguing that, are you giving up I want to make sure you understand the question the chief
Yes.
just asked. Are you giving up as a secondary way of affirming this case the way the appeals court did it? Because that's what the chief just asked you. Are you conceding we can't go that route?
No, I'm not.
Okay, that's what I didn't think you were
Okay.
doing that. Okay.
So, but how, I mean, well, I know it's late, but how are we going to find that the jury made a finding with regard to an uncharged crime based on their observation of a video? How does that give notice to anybody that that uncharged crime can be the basis for a conviction, which is a minimum of 5 years?
They watched a video where you can see the defendant strike the victim 3 distinct times. The prosecutor summarized that in his closing. So therefore, they saw the defendant strike the victim 3 times. It was only one charge that dealt with the assault and beating of the victim with the firearm.
But the jury...
They observed 3.
But the jury could have convicted him of the assault by the striking with the firearm as opposed to the shooting based on any of the 3.
That is correct.
So you'd have to find that actually they convicted him. Do we even know if they convicted him on the hitting over the head with the firearm or as opposed to the shooting?
It would go to whether...
It's both. He could have found guilty of both, but we don't know which of the 3.
Right. And I guess, as was posed at the appellate level, was there a substantial risk of a miscarriage of justice because the indictment didn't make clear? The defendant had the opportunity to ask for a bill of particulars. That did not happen. There were avenues he could have used at the trial level, and I don't believe the fact that the root felony wasn't there created that substantial risk.
Okay. Thank you.
Thank you very much.